Want to learn the entire constitutional law syllabus in under an hour?
Welcome to our marathon session on UK constitutional law. This podcast takes you through all the basics one needs to understand to prepare for an undergraduate law exam or the solicitor's qualifying examination. Challenge yourself to stick until the end and try to make some notes as you listen. This podcast is narrated by AI voices.
If you want to know more about how this podcast was put together, get in touch with Giannis using the details in the description of the podcast. The first step to understand constitutional law in the UK is to appreciate the meaning of the concept and to learn to differentiate between the main types of constitutions. Constitutions come in many forms. Some are written, meaning they are codified into a single documentary text, while others, like the UK's, are unwritten or uncodified. But this written or unwritten dichotomy is just one way to categorize constitutions. Scholars have developed numerous other classifications that can help us analyze and compare the constitutional systems of different states. One common classification looks at the ease which a constitution can be amended. We call constitutions that can be changed relatively easily flexible constitutions, while those that are harder to amend are termed rigid or inflexible. The UK Constitution is generally considered a prime example of a flexible constitution, since it can be amended simply by passing an Act of Parliament through the normal legislative process.
There are no special supermajority requirements or other hurdles that must be overcome.
In contrast, written constitutions often entrench amendment procedures to ensure that changes have broad support and are not made too hastily. Constitutions can also be classified as monarchical or republican, depending on whether the head of state is a hereditary monarch or an elected or appointed president. The UK, of course, falls on the monarchical side of this divide, although, as we'll discuss in more detail later, the monarch's role is largely ceremonial in the modern UK Constitution. Related to this is the distinction between parliamentary and presidential systems. In a parliamentary system like the UK's, the head of government, the Prime Minister, is a member of Parliament and is accountable to the legislature. In a presidential system, the head of government, the President, is separately elected and is not a member of the legislature. Federal and unitary constitutions are yet another important classification. Federal systems like the US and Australia divide power between a central national government and regional state governments, with each having their own constitutionally defined spheres of authority. Unitary systems like the traditional UK model concentrate power in the national government. However, the significant devolution of power to Scotland, Wales, and Northern Ireland in recent decades has led some to argue that the UK should now be categorized as a quasi-federal system. This brings us back to the UK Constitution and its uncodified nature. The lack of a written constitution raises some interesting conceptual questions. Some scholars like Ridley have argued that the lack of entrenchment, supremacy, and an external constituting power means that the UK doesn't actually have a constitution at all in the proper sense of the term.
But this is very much a minority view. The prevailing view is that the UK does indeed have a constitution, albeit an unwritten one.
The rules and principles that make up the Constitution are found not in a single document but in a variety of sources, including statutes, court rulings, conventions, and works of authority. While it may not have the trumping status of written constitutions in other jurisdictions, this body of law and practice performs the key constitutional functions of creating institutions, conferring powers, and regulating the relationships between the different branches of government and between the state and the citizenry. In the absence of a codified master text, the UK Constitution has an evolutionary quality and has proven itself capable of significant change over time. From the rise and fall of the welfare state consensus to the growing force of both populist and civil libertarian politics, to major reshaping of the UK's territorial governance through devolution, to the constitutional implications of Brexit, the UK Constitution is not a static thing, but a living tree, to borrow a famous metaphor. Then we turn our attention to three foundational principles of UK constitutional law: the separation of powers, the rule of law, and parliamentary sovereignty. Starting with the separation of powers.
This doctrine, which holds that the legislative, executive, and judicial functions of government should be divided among separate and independent bodies, is a cornerstone of many constitutional systems around the world. But what exactly does it entail, and to what extent is it reflected in the UK's constitutional arrangements? The intellectual origins of the separation of powers can be traced back to the ancient Greek philosopher Aristotle, who in his Politics identified three elements of every constitution: the deliberative, the officials, and the judicial.
However, it was the 18th century French political thinker Montesquieu who provided the doctrine's most influential exposition in his masterwork, The Spirit of the Laws. Drawing on his observations of the English system of government, Montesquieu argued that concentrating legislative, executive, and judicial power in the same hands, be it those of an individual or an institution, would lead to the loss of liberty and the rise of tyranny. Only by distributing these powers among separate actors, he contended, could freedom be preserved and the rule of law maintained. Montesquieu's ideas had a profound impact on the framers of the U.S. Constitution and have since become a central tenet of constitutional thought in many parts of the world. But what of the UK?
Can it be said that the Mother of Parliaments herself adheres to this key principle of constitutionalism?
The short answer is no, at least not in the strict sense of a pure separation of powers as envisaged by Montesquieu.
A cursory examination of the UK's constitutional arrangements reveals multiple instances of overlap and intermingling of the three governmental functions.
The executive, in the form of the Prime Minister and Cabinet, are all members of a legislature. Government ministers exercise a legislative function, both in Parliament and through the making of delegated legislation.
The courts, despite their primary judicial role, also engage in lawmaking through the development of the common law.
And until recently, the office of Lord Chancellor straddled all three branches, being simultaneously a member of the executive, the legislature, and the judiciary. These overlaps led many scholars of the Constitution to conclude that the separation of powers was simply not a feature of the British system. Writing in the 1950s, the public law scholar Robson memorably dismissed the doctrine as that antique and rickety chariot, which for too long had conveyed fallacious ideas in the minds of political and legal thinkers. However, this academic consensus stood in stark contrast to the views expressed by the judges, who on numerous occasions asserted the fundamental importance of the separation of powers to the UK Constitution. In cases such as Duport-Steeles v. Sears and the Pinochet litigation, the law lords spoke of the British Constitution being firmly based on a separation between the lawmaking function of Parliament and the law-interpreting function of the courts. Even in the Hines case, which concerned the constitution of a former colony, the Privy Council was prepared to read a separation of powers into the arrangements based on their assumption that those who drafted the Constitution would have been steeped in the British tradition. So, who is right? The academics with their emphasis on the messy realities of institutional overlap, or the judges with their insistence on the foundational status of the separation of powers ideal?
I would suggest that the truth lies somewhere in between. While it is certainly true that the UK does not display a pure separation of powers in the sense of a rigid demarcation of functions, there is nevertheless a real and meaningful separation between the judicial branch and the other two organs of government.
We continue with the rule of law, a core principle of the UK Constitution that is as important as it is difficult to define with precision.
The rule of law is one of those concepts that can mean different things to different people.
To a constitutional lawyer, it may signify a set of basic principles that lend stability and coherence to the legal system. To a politician, it may be a rhetorical device used to criticize the governance of other nations.
And to an ordinary citizen, it may represent the idea that no one, no matter how powerful, is above the law.
At its most basic, the rule of law encompasses a body of principles designed to restrain the abuse of power by ensuring that the exercise of authority is grounded in clear, open, and prospective rules. These principles include things like the independence of the judiciary, the right to a fair hearing, equality before the law, and access to the courts. The exact content and scope of the rule of law may vary from society to society, but these core tenets are widely recognized as essential to its realization. The ideas underpinning the rule of law have a long pedigree in English legal thought, stretching back at least as far as Magna Carta. but it was the Victorian jurist Dicey who gave the concept its most influential formulation in his classic work Introduction to the Study of the Law of the Constitution. For Dicey, the rule of law encompassed three key elements: the absence of arbitrary power on the part of the government, the equal subjection of all classes to the ordinary law administered by the ordinary courts, and the fact that the rights of individuals are derived from the ordinary law of the land rather than from a written constitution. Dicey's conception of the rule of law has not been immune from criticism.
His claim that discretionary power is incompatible with the rule of law seems hard to sustain in light of the vast growth of such powers in the modern administrative state.
And his assertion that everyone is subject to the same laws overlooks the fact that the law often treats different categories of persons differently, such as children or foreign diplomats. Nevertheless, Dicey's analysis remains a touchstone for much contemporary thinking about the rule of law. In more recent years, scholars have sought to distinguish between formal and substantive conceptions of the rule of law. A formal conception is concerned with the manner in which the law is promulgated, the clarity of the ensuing norm, and the temporal dimension of the enacted law. A substantive conception goes further and seeks to inject elements of justice and human rights into the concept of the rule of law.
On this view, a state that enacts laws that grossly violate human rights cannot be said to comport with the rule of law, even if those laws are clear, prospective, and enacted through proper procedures.
The tension between formal and substantive understandings of the rule of law has played out in a number of high-profile cases in recent years.
In the Belmarsh case, the House of Lords had to consider whether the indefinite detention without trial of foreign terror suspects was compatible with the rule of law.
The majority accepted that a public emergency threatening the life of the nation existed, but held that the detention scheme was both disproportionate and discriminatory and hence unlawful. In the BE case, the House of Lords upheld the Serious Fraud Office's decision to halt an investigation into alleged corruption by a major British arms company, citing threats by the Saudi government to withdraw counter-terrorism cooperation if the investigation continued. Critics saw this as a sacrifice of the rule of law on the altar of political expediency.
These cases illustrate both the importance and the contestability of the rule of law in contemporary Britain.
In the absence of a written constitution, the rule of law remains a vital safeguard against the abuse of power by government.
Yet reasonable people can and do disagree about what precisely the rule of law requires in any given case. Resolving those disagreements is an ongoing task for judges, lawmakers, and citizens alike.
We turn our attention to one of the most fundamental principles of the British Constitution, the doctrine of parliamentary sovereignty. This doctrine holds that Parliament has the right to make or unmake any law, and that no person or body has the authority to override or set aside its legislation. It is, in the words of the great Victorian jurist Dicey, the very keystone of the law of the Constitution. The origins of parliamentary sovereignty can be traced back to the momentous events of the Glorious Revolution in 1688. The overthrow of James II and the accession of William and Mary marked a decisive shift in the balance of power between the monarch and Parliament. The Bill of Rights 1689 declared that the levying of taxation and the raising of an army could not be done without parliamentary consent.
From that point on, it was Parliament, not the King, that held the reins of legislative power.
As the eminent legal historian Maitland put it, we have no theory of the sovereignty of king and parliament as two powers which are to check and balance each other. Our theory is that of the absolute sovereignty of a king and parliament. This absolute legislative authority of parliament has been repeatedly affirmed by the courts over the centuries. Time and again, judges have declared their duty to obey acts of parliament, however unwise or distasteful they may consider them to be. In the words of Lord Reed in the Madzimba Muto case, if Parliament chose to do any of them, the courts could not hold the Act of Parliament invalid.
This is not to say that there are no constraints whatsoever on what Parliament can do. Political realities and moral considerations act as powerful checks on its theoretical omnipotence. But from a purely legal perspective, the supremacy of parliamentary legislation is absolute.
Or is it?
In recent years, some jurists and scholars have begun to challenge the orthodox Diceian view of parliamentary sovereignty.
They argue that the doctrine has been qualified by a number of developments, both domestic and international. Foremost among these is the UK's former membership of the European Union. The case of Factortame, in which the House of Lords disapplied provisions of a British statute that were incompatible with EU law, seemed to strike at the very heart of the notion that Parliament cannot bind its successors.
For some, like Sir William Wade, it represented nothing less than a constitutional revolution. Others, however, saw it as a more limited concession, voluntarily made by Parliament itself through the European Communities Act 1972, and subject to revocation at any time.
The doctrine of implied repeal, another corollary of parliamentary sovereignty, has also come under strain in recent years.
Traditionally, it has been assumed that where two statutes are in conflict, the later one will impliedly repeal the earlier to the extent of any inconsistency.
But in the Thoburn case, the Divisional Court posited a new category of constitutional statutes that are immune from implied repeal.
These include such fundamental laws as Magna Carta, the Bill of Rights, the European Communities Act, the Human Rights Act, and the Devolution statutes. While ordinary statutes can still be impliedly repealed, constitutional statutes can only be expressly repealed, reflecting their special status in the legal order.
And then there is the vexed question of the Acts of Union 1707, which joined England and Scotland into the new state of Great Britain. Some Scottish lawyers have argued that these acts contain provisions that were intended to be immutable, such as the guarantee of the continued existence of the Court of Session. If this is correct, it would mean that the Westminster Parliament is not in fact sovereign, but is bound by the terms of the Union settlement. However, most constitutional scholars regard this as a heretical view, pointing to the numerous occasions on which the Union legislation has been amended or repealed by later parliaments. Perhaps the most significant challenge to parliamentary sovereignty in recent years has come from the Human Rights Act 1998. While the Act preserves the formal supremacy of Parliament, it requires the courts to interpret legislation in a way that is compatible with the European Convention on Human Rights, so far as it is possible to do so. Where such an interpretation is not possible, the higher courts may issue a declaration of incompatibility, which signals to Parliament that the law needs to be changed. Some have seen this as a surreptitious form of judicial strike-down power, with judges effectively able to disapply acts of Parliament on human rights grounds. Others argue that it is a more nuanced constitutional dialogue in which the courts flag issues for Parliament's attention, but ultimately leave the final say to the legislature. In the end, the true scope and meaning of parliamentary sovereignty in the modern British Constitution remains contested. While the orthodox Dycean view still holds sway in most quarters, there are signs that it is being gradually eroded by the countervailing forces of EU law, constitutional statutes, devolution, and human rights. Some, like Lord Steyn, have even suggested that in truly exceptional circumstances such as an attempt to abolish judicial review, the courts might have to qualify the doctrine in order to preserve the rule of law. But for now, the principle that Parliament can make or unmake any law, and that its word is law, remains the bedrock of our constitutional order. As Lord Bingham put it, the British Parliament has the right to make or unmake any law whatsoever, and no person or body has the right to override or set aside the legislation of Parliament. This is the essence of parliamentary sovereignty, and it is a principle that, for all the challenges it faces, is likely to endure for some time to come. Having laid out these fundamental principles, we move to the institutional framework of the Constitution, and we start with the Parliament.
Composed of the House of Commons, the House of Lords, and the monarch, Parliament is the supreme lawmaking body in the United Kingdom.
It is the fountain from which all legislative authority flows. Let's begin with the House of Commons, the elected chamber and the democratic engine of Parliament.
The right to vote for members of the Commons, known as the franchise, has been hard-won over centuries of political struggle.
Once restricted to a privileged few based on property ownership, the franchise was gradually extended through a series of reform acts in the 19th and early 20th centuries. Today, the right to vote is enjoyed by all British, Irish, and Commonwealth citizens over the age of 18 who are resident in the UK, subject to a few exceptions such as members of the House of Lords and those serving prison sentences. This broad-based franchise is reflected in the composition of the Commons, which currently consists of 650 members, elected from single-member constituencies using the first-past-the-post voting system.
This means that the candidate with the most votes in each constituency is elected, even if they don't achieve an absolute majority.
While simple and decisive, this system has been criticized for producing disproportional outcomes, where a party's share of seats doesn't match its share of the national vote. Alternatives like the alternative vote and forms of proportional representation have been proposed, but a referendum in 2011 saw voters decisively reject a change to AV. Turning to the upper chamber, the House of Lords is a very different beast. Whereas the Commons is an elected body, the Lords is largely appointed, with most members being life peers created by the monarch on the advice of the Prime Minister. This is supplemented by 92 hereditary peers elected from within their own ranks, and 26 bishops of the Church of England known as the Lords Spiritual. This anachronistic composition has long been a source of controversy, with critics condemning it as undemocratic and calling for wholesale reform. The most significant attempt at Lords reform in recent years was the House of Lords Act 1999, which removed the automatic right of hereditary peers to sit in the chamber.
However, in a compromise move, 92 hereditary peers were allowed to remain until further reforms could be agreed.
Subsequent efforts to move to a largely or wholly elected second chamber have all foundered in the face of political disagreement. More modest changes in the 2014 and 2015 Acts have allowed peers to retire and provided for the expulsion of members in certain circumstances, but the fundamental character of the Lords remains unchanged. Despite its unelected status, the House of Lords plays an important role in the legislative process. While the Commons has primacy, all bills except money, bills must be passed by the Lords to become law. The Lords act as a revising chamber, scrutinizing legislation and proposing amendments. Many of its members have valuable expertise in particular fields that allows them to improve the technical quality of bills.
And while the Lords conventionally defers to the Commons on major policy issues, it occasionally flexes its muscles, as when it defeated the government 49 times over the EU withdrawal bill in 2018.
Parliament has occasionally seen fit to impose procedural restrictions on itself, as with the manner and form provisions of the Parliament Acts 1911 and 1949. These allow the Commons to bypass the Lords and enact legislation without their consent, but only if certain conditions are met, such as a minimum time gap between successive readings.
Whether such restrictions are truly binding is a matter of debate among constitutional theorists, but they are at least observed in practice. We now turn to the structure of the UK and devolution. Devolution, as you may know, refers to the transfer of powers from the central UK Parliament to regional legislatures in Scotland, Wales, and Northern Ireland. It's a process that has fundamentally reshaped the UK's constitutional landscape over the past few decades, and one that continues to evolve to this day.
The modern era of devolution began in the late 1990s following the election of Tony Blair's Labour government. Referendums were held in Scotland and Wales in 1997, with voters in both nations endorsing the creation of devolved legislatures. This was given effect through the Scotland Act 1998 and the Government of Wales Act 1998, which established the Scottish Parliament and the National Assembly for Wales respectively.
Northern Ireland followed suit a year later with the Northern Ireland Act 1998, implementing the devolution provisions of the Good Friday Agreement.
The powers of these devolved legislatures vary, but in general they have responsibility for matters like health, education, housing, and the environment within their territories. The UK Parliament retains control over reserved matters like foreign policy, defence, and macroeconomic policy. Crucially, it also retains the power to legislate on any issue, whether devolved or not, a principle known as parliamentary sovereignty. In practice, however, the UK Parliament will not normally legislate on devolved matters without the consent of the relevant devolved legislature, a convention known as the Zool Convention. The years since 1998 have seen a steady expansion of devolved powers, particularly in Scotland. The Scotland Acts of 2012 and 2016 have given the Scottish Parliament significant new tax-raising and welfare powers, as well as putting the permanence of the Scottish institutions on a statutory footing.
In Wales, the Government of Wales Act 2006 and the Wales Acts of 2014 and 2017 have seen a shift from a conferred powers model of devolution, where the Assembly only had powers specifically granted to it, to a reserved powers model like Scotland's, where it can legislate on anything, not explicit. Northern Ireland's devolution arrangements have been more intermittent, with the Assembly suspended for several periods due to political deadlock, but it too has seen a gradual expansion of its competences. Devolution has not been without its challenges.
The asymmetric nature of the UK's arrangements, with each nation having different powers, has led to a complex patchwork of governance. The English question, the fact that England, unlike the other nations, has no devolved legislature of its own, remains a thorny political issue.
And the 2016 Brexit referendum exposed deep fissures between the nations, with Scotland and Northern Ireland voting to remain while England and Wales voted to leave. But despite these difficulties, devolution has become an entrenched part of the UK's constitutional order.
It has provided a means for the distinct voices and interests of the nations to be heard and represented within the structures of the state. It has fostered innovation and policy divergence, with the devolved governments often acting as laboratories for new approaches. And it has perhaps helped to preserve the unity of the kingdom by providing an outlet for nationalist sentiment short of full independence. We now turn our attention to the sources of constitutional law, starting with primary and secondary legislation.
Let's start with primary legislation.
In a typical year, Parliament passes around 30 to 40 public general acts.
These are bills of general application that have successfully navigated the various stages of the parliamentary process in both the House of Commons and the House of Lords.
The vast majority of these are government bills introduced by ministers to give effect to the policies of the executive. The journey of a bill through Parliament is a multi-stage affair. It begins with the first reading, a purely formal stage where the bill is introduced without debate. This is followed by the crucial second reading, where the general principles and main purpose of the bill are debated. If the bill passes this hurdle, it proceeds to the committee stage, where a detailed clause-by-clause examination takes place, usually by a small specially convened public bill committee.
The bill may be amended at this stage before returning to the floor of the House for the report stage, where further amendments can be made.
Finally, the bill has its third reading, its last chance to be debated before being sent to the other house to go through a similar process. Assuming the bill passes through both houses, it will receive royal assent and become an Act of Parliament. However, it's important to note that even at this stage, not all of the Act's provisions may come into force immediately. Commencement orders may be needed to bring certain sections into effect, adding an extra layer of executive control to the legislative timeline. Not all primary legislation follows this template. Parliament also deals with various categories of special bill, each with its own unique procedures.
Private bills, for instance, are sponsored by organizations outside Parliament to obtain powers beyond or in conflict with the general law.
Hybrid bills mix public and private elements and are often used for major infrastructure projects of national importance.
And consolidation bills seek to tidy up the statute book by drawing together multiple enactments on the same subject into a single act, without substantive change to the law.
Turning to secondary legislation, this is something of a controversial necessity in the modern state. Parliament simply lacks the time and capacity to attend to every detail of every law, so it delegates legislative powers to ministers, public bodies, and other entities through enabling clauses in primary legislation. These delegated powers come in many forms: statutory instruments, orders in council, bylaws, rules, and are subject to varying degrees of parliamentary oversight. Some require active approval by both houses, others take effect, unless actively annulled, and some take effect with no parliamentary involvement at all. The key constitutional principle at play here is the sovereignty of Parliament. In theory, Parliament cannot bind its successors or be bound by its predecessors, so any delegation of legislative power is revocable by a future Parliament.
In practice, the picture is more complex.
The sheer volume of secondary legislation, the technicality of much of its subject matter, and the often perfunctory nature of the parliamentary scrutiny process all contribute to a sense that executive power has expanded at the expense of legislative supremacy. This tension is particularly apparent in the case of so-called enry, the eighth clauses, which allow ministers to amend or repeal primary legislation by secondary instrument. These clauses are named after the 16th century monarch's penchant for legislating by proclamation and are often seen as a constitutionally suspect transfer of power from Parliament to the executive. Their use has become increasingly common in recent years, particularly in the context of Brexit, where the need to attain EU law to a domestic context has been used to justify broad delegated powers. Ultimately, the balance between primary and secondary legislation reflects a broader tension in the UK Constitution between the principles of parliamentary sovereignty and executive efficacy.
On one hand, the legitimacy of the law rests on the democratic mandate of elected representatives in Parliament.
On the other, the complexity of modern governance demands a degree of flexibility and technical expertise that Parliament alone cannot provide.
Striking the right balance is a constant challenge, and one that is shaped as much by political realities as by constitutional doctrine.
The courts play an important role in policing the boundaries of delegated power through the ultra vires principle, but they are constrained by the will of Parliament as expressed in primary legislation. Parliamentary committees, such as the Joint Committee on Statutory Instruments, provide a degree of specialist scrutiny, but their impact is limited by time and resource constraints. In the end, the quality of the UK's legislative output depends on a delicate interplay between Parliament, the executive, the courts, and civil society. Primary legislation provides the essential democratic foundation, but secondary legislation is an unavoidable reality of modern government. The key is to ensure that the delegation of legislative powers is justified, circumscribed, and subject to meaningful scrutiny. Only then can the rule of law be reconciled with the demands of effective administration. We now turn our attention to a unique and often misunderstood feature of the British Constitution, the role of constitutional conventions. Unlike the legal rules that make up much of our constitutional framework, conventions are not enforced by the courts.
They are, in the words of the great constitutional scholar Dicey, understandings, habits, or practices that regulate the conduct of political actors, but which are not, in reality, laws at all. Yet despite their non-legal status, conventions play a vital role in the operation of our constitutional system.
They are, as another famous commentator, Walter Bagehot, put it, the unwritten maxims of the Constitution. So what exactly are constitutional conventions? At their core, they are rules of political practice that are regarded as binding by those to whom they apply, but which are not legally enforceable.
They are, in essence, a form of constitutional morality, a set of norms and expectations that govern the behavior of politicians and officials in the absence of hard legal constraints.
Conventions can emerge gradually over time as a matter of custom and usage, or they can be more deliberately created in response to specific constitutional needs or challenges. What they share is a recognition by political actors that they ought to be followed even if there is no legal compulsion to do so. The scope of constitutional conventions is broad and varied. They regulate matters such as the appointment of the Prime Minister, the exercise of the royal prerogative, the collective responsibility of the cabinet, the impartiality of the civil service, and the relations between the different branches of government. In many cases, they serve to fill in the gaps left by the formal legal rules, providing a flexible framework for the day-to-day operation of government. In others, they act as a restraint on legal powers, preventing the abuse of authority and ensuring that government is conducted in accordance with fundamental constitutional principles. A prime example of the latter is the doctrine of individual ministerial responsibility.
This is the convention that ministers are accountable to Parliament for their own conduct and for the actions of their department. In theory, a minister who misleads Parliament or who presides over serious failures in their department is expected to resign. This convention acts as a check on executive power, ensuring that ministers cannot hide behind the anonymous machinery of the state.
It is a key mechanism by which Parliament holds the government to account. Another important convention is that of collective cabinet responsibility.
This requires ministers to publicly support government policy, even if they disagree with it in private.
The convention ensures that the government speaks with one voice and presents a united front to Parliament and the public. It is a recognition of the fact that the government's authority derives from its ability to command the confidence of the House of Commons as a collective body. A divided cabinet is a weak cabinet, and the Convention of Collective Responsibility is designed to prevent such divisions from emerging.
Of course, like all rules, conventions can be broken. Ministers do sometimes publicly dissent from government policy. They are not always required to resign when things go wrong in their departments.
The force of a convention depends on the continued willingness of political actors to abide by it and on the consequences that follow from a breach.
In some cases, the breach of a convention will be seen as a serious matter, meriting severe political sanction. In others, it may be overlooked or excused, especially if there are mitigating circumstances.
This points to a key feature of conventions, their flexibility. Unlike legal rules, which are rigid and precise, conventions can evolve and adapt over time to meet changing political realities. They are not set in stone, but are rather a living part of our constitutional tradition. This can be both a strength and a weakness. On the one hand, it allows conventions to keep pace with the development of the Constitution and the needs of the political system.
On the other, it can lead to uncertainty and disagreement about what the conventions actually require in any given situation. This uncertainty is compounded by the fact that conventions are not always easy to identify.
As unwritten rules, they must be inferred from constitutional practice and the statements of authoritative figures. This has led some commentators such as Sir Ivor Jennings to propose tests for the existence of a convention based on factors such as precedent, the beliefs of political actors, and the reasons for the rule. But these tests are not always conclusive, and there can be reasonable disagreement about whether a particular practice has achieved the status of a convention. Despite these difficulties, the importance of conventions to the British Constitution is clear. They provide the flesh on the bones of the legal framework, filling out the bare structure of the law with a set of working principles and understandings.
They ensure that the Constitution operates in a way that is politically acceptable and democratically legitimate, even if not always legally mandated.
And they provide a means by which the Constitution can evolve and adapt to meet new challenges and circumstances. In recent years, there have been some moves towards greater formalization of conventions. The Cabinet Manual, first published in 2011, seeks to codify many of the key conventions relating to the operation of government. And some conventions, such as the Sewell Convention governing the UK Parliament's legislative power over devolved matters, have been given a measure of statutory recognition. But these developments have not fundamentally altered the non-legal status of conventions, nor their central role in the British constitutional system. In the end, the continuing relevance of conventions is a testament to the enduring strength of the British political tradition. In a constitution that is largely uncodified and unentrenched, conventions provide a vital source of continuity and stability. They represent a shared commitment to certain fundamental principles and understandings passed down from generation to generation of political actors. And they remind us that, at its heart, a constitution is not just a set of legal rules, but a living political system sustained by the beliefs and practices of those who operate within it.
We now turn to judge-made law as an important source of the UK Constitution.
For many years, judges were reticent to acknowledge their lawmaking role. In 1892, Lord Esher remarked, "There is, in fact, no such thing as judge-made law, for the judges do not make the law, though they frequently have to apply existing law to circumstances as to which it has not been authoritatively laid down that such law is applicable." However, this view gradually evolved to acknowledge the reality that judges do indeed make law, even if they don't do so as directly and explicitly as the legislature. As Lord Reed explained, the notion that judges merely discover the common law rather than creating it through their rulings is a fairy tale that modern jurists no longer ascribe to. The lawmaking role of the judiciary is now widely accepted. Judicial lawmaking takes two main forms: one, the development of the common law through legal precedents, and two, the interpretation of statutes passed by Parliament. Let's look at each in turn. The common law comprises the rules and principles declared by the courts to be the law of the land. Classic examples include Entick v. Carrington in 1765, which established that government interference with property rights requires prior legal authorization, and the 1994 case of M v. Home Office, which held that even government ministers can be held in contempt of court for violating judicial orders. The courts have developed the common law over time to uphold individual rights and hold the executive accountable.
However, the courts have also shown restraint in some areas, such as refusing to recognize a general right to privacy in cases like Kay v. Robertson and Malone v. Metropolitan Police Commissioner.
As Sir Robert Megory explained, while extending existing law is one thing, wholly creating new rights is a matter best left to Parliament.
The courts make law interstitially and incrementally rather than in broad strokes. When it comes to interpreting statutes, the courts aim to give effect to the will and intention of Parliament.
However, as Baroness Hale noted, divining parliamentary intent is often an illusion, since the specific matter at hand was frequently not contemplated when the law was drafted. Therefore, the role of the courts is to deduce the intention from the words used in light of the statutory purpose. Two main approaches are used: the literal approach, focusing on the plain meaning of the words, and the purposive approach, looking at the broader aim of the legislation. The literal approach was favored by jurists like Viscount Simons and Lord Devlin, who believed the courts should not obstruct the clear words of a statute. However, the purposive approach has gained prominence, especially for legislation implementing European Union directives. The courts have been willing to read additional words into statutes to ensure consistency with EU law.
The courts also rely on certain presumptions when interpreting statutes, such as that Parliament does not intend to restrict access to justice or make laws retroactive. However, these are just presumptions that can be overridden by clear statutory language.
In conclusion, while the primary lawmaking role rests with Parliament, judge-made law through common law development and statutory interpretation is an important source of the UK Constitution. The courts aim to uphold individual rights and give effect to parliamentary intent, but they are also cognizant of the constitutional limits on their own lawmaking powers. Judicial lawmaking tends to be gradual and incremental rather than sudden and sweeping. The Human Rights Act 1998 imposes as a strong duty on the courts to interpret legislation compatibly with the European Convention on Human Rights, if at all possible.
This reflects Parliament expressly instructing the courts to engage in creative interpretation in the specific context of protecting human rights.
But in general, the constitutional separation of powers means there are boundaries to the judicial lawmaking role that the courts must respect. Finally, we will be exploring the royal prerogative as an important source of constitutional authority in the UK. The prerogative refers to those powers that are unique to the Crown and derived from common law rather than granted by statute. In the past, these powers were exercised at the monarch's personal discretion.
However, over time, especially since the pivotal constitutional settlement reached in the Glorious Revolution of 1688, prerogative authority has increasingly shifted into the hands of the executive, with the monarch acting on the advice of the government of the day. Only a few personal prerogatives are still exercised by the sovereign, such as the right to grant certain honors.
A leading constitutional scholar, Dicey, defined the prerogative broadly as any action the executive can lawfully take without statutory authorization. However, others contend this definition is overly expansive, preferring Blackstone's original formulation, limiting it to those powers that are unique to the Crown. While the full scope of the prerogative is not comprehensively defined, some key examples include the power to appoint and dismiss ministers,
the right to summon, prorogue, and dissolve Parliament, the ability to grant royal assent to legislation,
powers related to foreign affairs like treaty-making and declaring war,
the prerogative of mercy to pardon convicted offenders. Importantly, when prerogative powers come into conflict with statutory authority, it is now well established that statute prevails.
Parliament can expressly abolish or limit prerogatives through legislation. The Crown is then bound by the will of Parliament under the principle of parliamentary sovereignty. The role of the courts in relation to the prerogative has evolved significantly in modern times. Historically, judges were willing to define the existence and extent of prerogative powers, but not to review how they were exercised. This changed with the GCHQ case in 1985, which established that many prerogative powers were now judicially reviewable on ordinary public law grounds of legality, rationality, and procedural propriety. However, the courts outlined certain categories of prerogative power considered off-limits for judicial scrutiny, especially those involving matters of high policy like treaty-making, declaring war, or the appointment of ministers. The boundaries continued to shift, though, with the 2019 Miller-Cherry ruling, finding that even the prorogation of Parliament could be reviewed if its effect was to frustrate parliamentary sovereignty without reasonable justification.
Looking ahead, there have been calls to further reform the prerogative, whether by codifying all powers in statute, selectively replacing certain prerogatives with a statutory framework, or increasing parliamentary oversight of how key prerogatives are exercised. The balance between executive discretion and democratic accountability in this area remains a live issue.
What is clear is that the ancient concept of the royal prerogative retains a central relevance to the modern UK Constitution.
Our next topic is judicial review of administrative action. Judicial review is the procedure by which courts assess the lawfulness of decisions made by public bodies in the exercise of their executive powers.
It is crucial to understand that judicial review is fundamentally supervisory rather than appellate in nature.
Courts are concerned with the legality of the decision-making process itself, not the merits of the ultimate decision reached.
Judges do not substitute their own views for those of the original decision-maker. Lord Donaldson memorably compared the judicial role to that of a referee in a football match, there to enforce the rules of the game, not to dictate tactics or strategy to the players. This limited remit respects the separation of powers between the judiciary and the executive. However, while courts conducting judicial review must not trespass into the domain of assessing a decision's merits, that does not mean executive discretion is unfettered. The courts have repeatedly emphasized that statutory grants of discretionary power to ministers or public bodies must be exercised within certain legal boundaries.
Such discretion is never truly absolute.
The Padfield case illustrates this well. Even a seemingly open-ended power for a minister to act as they think fit to further a statute's purposes was interpreted as imposing real constraints. The House of Lords held the minister was obliged to exercise his discretion to promote the policy and objects of the Act, as discerned from the legislation as a whole. He could not pursue unrelated policy goals. Later cases like Ex parte Hammersmith and Fulham LBC reinforced that discretion must always be used to advance proper statutory purposes.
Another important limitation is that discretion must be exercised in accordance with public law principles like natural justice, as well as the Human Rights Act 1998.
Decision-makers cannot act arbitrarily or unfairly.
However, there is debate over whether some of the recognized grounds of judicial review, which we'll explore in a later lecture, risk the court's straying into ruling on the merits, rather than just legality of decisions.
A key procedural reform to judicial review is the rule from O'Reilly v. Mackman that public law challenges should normally be brought through the judicial review procedure, not an ordinary civil claim. This preserves the distinctiveness of public law and prevents collateral attacks on public decisions.
However, later cases have adopted a more flexible approach, emphasizing avoiding abuse of process over procedural technicalities.
Judicial review is also subject to various limits, such as narrow rules on standing, short time limits for claims, and occasional attempts by Parliament to oust the jurisdiction of the courts through privative clauses. The effectiveness of ouster clauses remains a contested constitutional question regarding the rule of law and separation of powers. In conclusion, judicial review plays a vital role in upholding the rule of law and preventing abuse of executive power. But it operates within clear boundaries as a supervisory rather than appellate jurisdiction. Courts walk a delicate line between enforcing legal constraints on discretionary powers, while respecting the constitutional limits of the judicial role vis-a-vis the executive and legislature. The procedure remains a powerful tool for holding government accountable, even as the scope for challenging public decisions evolves over time. We now turn to grounds of judicial review. These are the bases upon which courts can assess the legality of decisions made by public bodies and potentially quash them. Identifying the grounds for review is crucial for understanding the proper scope and limits of the judiciary's supervisory jurisdiction over the executive branch.
There are three main heads of judicial review: illegality, irrationality, and procedural impropriety.
This useful framework was articulated by Lord Diplock in the seminal GCHQ case.
However, the various grounds for challenging administrative decisions often overlap in practice.
A public body's conduct may be impugned on multiple intersecting bases. Starting with illegality, a key principle is that decision-makers must correctly understand the law governing their powers and give effect to it.
This means acting within the scope of their statutory mandate or other source of authority.
An important aspect of illegality is taking into account irrelevant considerations or failing to consider relevant factors when exercising discretion. The landmark Padfield case illustrates how even a seemingly unfettered statutory power must be exercised to promote the policy and objects of the Act as discerned from the legislation as a whole.
Closely linked to this is the principle that discretionary powers must be used for proper statutory purposes, not unauthorized or collateral aims.
Attempts to use discretion for improper purposes, such as punishing individuals as seen in Wheeler v. Leicester City Council, or foisting burdens on developers that Parliament did not intend, as in Hall & Company Limited v. Shoreham, have been roundly condemned by the courts.
There are also cases suggesting public bodies owe fiduciary duties to ratepayers to not act thriftlessly, as in Bromley LBC v. GLC.
Additionally, decision-makers must not fetter their discretion by applying overly rigid policies as in British Oxygen.
Even relevant policies cannot preclude considering significant counter-arguments.
Nor can discretion be fettered by blindly following edicts from other sources, such as political parties, if that means failing to genuinely consider the merits. Turning to irrationality, the classic Wensbury unreasonableness test sets a high threshold.
It covers decisions so outrageous in their defiance of logic that no sensible person applying their mind to the question could have arrived at them.
More recently, there has been debate about whether proportionality, a more intensive standard of substantive review, should be adopted as a general head of review like in human rights cases.
This remains controversial due to concerns about the constitutional implications of courts more readily substituting their views on the merits of decisions for those of the primary decision-makers.
Finally, procedural impropriety encompasses breaches of mandatory statutory procedures, as well as the common law standards of natural justice or fairness. The right to a fair hearing and rule against bias are fundamental to this. Courts have recognized the content of these standards varies depending on context. More exacting procedural protections are required where decisions have serious consequences for individuals. Legitimate expectation is another aspect of fairness. Deliberate breaches of procedural promises can be an abuse of power.
In some cases, fairness may even necessitate giving reasons, although there is debate over whether this should be a general common law obligation.
In conclusion, the grounds for judicial review demonstrate both the potential breadth and limits of the court's supervisory jurisdiction.
While the various heads of review afford considerable scope for scrutinizing administrative action, constitutional considerations mean courts remain wary of trespassing into impermissible merits review.
Striking this delicate balance remains an ongoing challenge.
Nevertheless, the grounds for judicial review remain crucial for holding public bodies accountable under the rule of law. Moving on to judicial remedies, there are several key remedies a court may grant if it finds in favor of the claimant.
However, it's crucial to understand that these remedies are discretionary.
A court is not obliged to grant them even where a claimant has proven their case on the substance.
This underscores the supervisory rather than appellate nature of the judicial review jurisdiction. The main remedies are the prerogative orders of a quashing order, prohibiting order, and mandatory order, as well as declarations and injunctions. Each serves a distinct purpose. A quashing order nullifies an ultra vires decision. A prohibiting order stops a public body from acting or continuing to act unlawfully. A mandatory order compels performance of a public law duty.
In contrast, a declaration is a statement of the legal position which guides the party's future conduct. Injunctions require or prohibit specified acts and can be granted on an interim basis.
Interestingly, damages are not a primary judicial review remedy, although they may be claimed in addition to a public law remedy if the claimant could have obtained them in private law proceedings. The Law Commission has argued there is a case for making damages more widely available to compensate claimants for losses caused by unlawful administrative action.
However, this would mark a significant shift, given judicial review's focus on legality rather than individual redress. A key theme is the court's reluctance to grant coercive remedies against public bodies unless strictly necessary.
Prohibiting or mandatory orders compelling or forbidding certain conduct are seen as a last resort.
The courts often prefer to grant a declaration to clarify the law, trusting that public bodies will then comply voluntarily without the need for a coercive order.
This reflects constitutional sensitivity about the judiciary overstepping into the executive's domain. There is also caution about quashing subordinate legislation or major administrative schemes due to the far-reaching practical consequences of nullifying them. Substitutionary remedies, where a court replaces an unlawful decision with its own, are only available in limited statutory circumstances to avoid trespassing into merits review. Recent developments include the new power to grant interim declarations and legislative changes to restrict relief, where an error was highly unlikely to have affected the outcome for the claimant.
The government's Judicial Review in Courts bill also proposes reforming quashing orders to give courts the power to suspend, limit, or remove their retrospective effect. This reflects concern about the disruptive impact of quashing on good administration and third parties, although some worry it may leave successful claimants without a meaningful remedy.
In conclusion, the remedies available in judicial review demonstrate both the strengths and limits of the jurisdiction.
While there is a powerful arsenal of remedies to address unlawful administrative action, their discretionary nature and the court's cautious approach to deploying them underscore the focus on policing legality rather than providing individualized redress.
The constitutional constraints of the judicial role mean the primary responsibility for remedying defective administrative action often remains with public bodies themselves.
Nevertheless, judicial review remedies remain vital for upholding the rule of law. We now move to human rights and civil liberties as our final focus for this lecture.
A central question is whether human rights and civil liberties are distinct concepts.
Some argue that human rights are more fundamental and impose positive duties on the state, while civil liberties are freedoms from state interference.
In practice, though, the two are closely related, and the terms are often used interchangeably. Historically, the UK relied on the common law, as developed by the courts, to safeguard individual liberties against arbitrary state action. Landmark cases like Entick v. Carrington in 1765 established key principles, such as that the executive cannot interfere with property rights without clear legal authority.
However, the traditional approach had limitations, especially given the doctrine of parliamentary sovereignty, which allows even basic liberties to be overridden by statute.
The European Convention on Human Rights, DCHR, drafted in 1950, represented a major shift. For the first time, states committed to protecting a defined set of fundamental rights, with an international court, the European Court of Human Rights, to hold them accountable.
The ECHR protects core civil and political rights, such as the right to life, freedom from torture, liberty and security of the person, fair trial rights, privacy, freedom of conscience and expression, and non-discrimination.
Some rights are absolute, like the prohibition on torture, but most allow for restrictions if they are prescribed by law, pursue a legitimate aim, and are necessary and proportionate in a democratic society. The UK was instrumental in drafting the ECHR, but for many decades resisted calls to incorporate it directly into domestic law. This meant individuals had to take the long and costly route of petitioning the Strasbourg Court to vindicate their convention rights. It was only with the landmark Human Rights Act 1998 that the ECHR was finally brought home, allowing direct enforcement in UK courts. The Human Rights Act imposes a duty on all public authorities to act compatibly with convention rights, unless compelled to do otherwise by primary legislation.
One key issue has been determining exactly which bodies are covered. The courts have interpreted public authority to include core state bodies and some private entities performing public functions. But where to draw the line remains contested. Courts must interpret legislation compatibly with convention rights if possible, and can issue a declaration of incompatibility if not.
Under the mirror principle, they should normally follow clear and constant jurisprudence from the European Court of Human Rights, but can depart from it if there are good reasons.
Higher courts can also make a declaration of incompatibility with the ECHR, prompting the government to consider amending the offending legislation. While the Human Rights Act has had a major impact, it maintains parliamentary sovereignty and does not enable courts to invalidate primary legislation for breaching human rights.
Some argue the UK should go further and entrench a Bill of Rights with even stronger judicial protection, perhaps drawing on international human rights instruments to include socio-economic rights and environmental protections alongside the core civil and political liberties. However, there are also political pressures to replace the Human Rights Act with a British Bill of Rights that would reassert the primacy of domestic courts and limit the influence of Strasbourg jurisprudence. The government recently commissioned an independent review of the Act, though a parliamentary committee has warned that any substantial weakening of its protections would risk breaching the UK's international obligations. In conclusion, the story of human rights and civil liberties in the UK Constitution remains one of evolution and contestation. The Human Rights Act was a landmark achievement in aligning British law more closely with European human rights standards while preserving parliamentary supremacy. But debate continues on whether it strikes the right balance or should be replaced by a more extensive British Bill of Rights. Ultimately, the effectiveness of any human rights protections will depend not just on the legal framework, but a culture of respect for fundamental rights and the rule of law across all branches of government. One of the most important areas in human rights is the freedom of expression. We will be exploring how the law seeks to balance the fundamental right to freedom of expression with other competing interests, focusing on two key areas: obscenity and contempt of court. Freedom of expression is a cornerstone of any democratic society enshrined in Article 10 of the European Convention on Human Rights. However, it is not an absolute right. The law recognizes that there are certain circumstances where restrictions may be necessary and justified. Two important examples are where expression is deemed obscene and corrupting, or where it risks undermining the administration of justice. Starting with obscenity, the primary legislation is the Obscene Publications Act 1959.
It makes it a criminal offense to publish any article that tends to deprave and corrupt those likely to read, see, or hear it.
This deprave and corrupt test has been much criticized as vague and anachronistic, but it essentially targets sexually explicit and other offensive material judged to be morally harmful to consumers. Importantly, the 1959 Act looks at the overall effect of a publication taken as a whole.
So artistic or literary merit can form a defense, even if a work contains some obscene passages. The audience also matters. Material is only obscene if it would actually tend to deprave and corrupt a significant proportion of its likely consumers. Over time, obscenity law has expanded beyond its original focus on sexual immorality.
It now encompasses graphic violence, drug taking, and other matters. The courts have said the category of what is deemed obscene can evolve as society's values change. But this flexibility comes at the price of some uncertainty in applying the law.
Parliament has also legislated to criminalize mere possession of extreme pornography, depicting acts like necrophilia or bestiality. This targets the moral harm to individual consumers, not just the general public.
It's a more paternalistic approach, resting on the extreme nature of the material rather than the 1959 Acts Corrupting Effects test.
Turning to contempt of court, the key statute is the Contempt of Court Act 1981.
It aims to prevent media reporting that could prejudice active legal proceedings and impede the administration of justice. The 1981 Act imposes strict liability. No intent to interfere with the course of justice is required, only the creation of a substantial risk of serious prejudice. This strict liability rule only applies to publications made when proceedings are active, as defined by the Act.
So it covers the period from arrest to acquittal or sentencing.
Breaching the rule can lead to criminal sanctions, but there are defenses for fair and accurate reporting or incidental prejudice during discussion of matters of public interest. The 1981 Act also allows the courts to impose temporary reporting restrictions or anonymity orders in certain cases. These are meant to be a last resort where necessary to prevent a substantial risk of prejudice.
But they remain a significant derogation from open justice, which is a fundamental principle requiring legal proceedings to be conducted transparently in public.
The Internet age has created new challenges for regulating obscene and prejudicial speech. It is easier than ever for extreme and harmful content to proliferate online, often on sites beyond domestic jurisdictional reach. But attempts to broaden the law's scope can be criticized as unduly restricting free expression. Similarly, social media commentary on active court cases by ordinary individuals, not just professional journalists, risks trial by Twitter that undermines fair judicial processes.
But heavy-handed regulation of online speech raises its own rule of law concerns.
In the end, the legal framework around obscenity and contempt involves a delicate balance between freedom of expression and the protection of other vital social interests.
As social values and technologies evolve, the law too must adapt to keep that balance properly calibrated.
Resolving this tension will remain a key challenge in our contemporary constitutional democracy. We move to another important issue related to human rights police powers in the UK. We will be focusing particularly on the powers under the Police and Criminal Evidence Act 1984.
These include stop and search, arrest and entry, and search of premises. We will also consider the role of police discretion in exercising these powers, and the extent to which the courts can review their use. It's important to recognize at the outset that police powers necessarily involve significant intrusions on individual liberty. Stopping someone in the street, arresting them, or searching their home are among the most coercive actions the state can take against a citizen. That's why the exercise of police powers is governed by a detailed legal framework, balancing the needs of effective law enforcement with the rights of the individual. The central statute is PACE, which aimed to clarify and codify police powers while introducing new safeguards.
It is supplemented by detailed codes of practice.
Let's begin with stop and search, one of the most controversial police powers given its disproportionate use against ethnic minorities.
PACE Section 1 allows an officer to detain a person or vehicle in a public place to search for prohibited articles if they have reasonable grounds for suspicion.
Reasonable suspicion is an objective test. There must be some factual basis, not just a hunch or prejudice.
The officer must give their name, station, and grounds for the search. A record must be made and a copy provided if requested. Certain other statutes allow suspicionless stop and search in some circumstances, such as Section 60 of the Criminal Justice and Public Order Act, 1994. These are even more contentious as they rely solely on an authorization by a senior officer in anticipation of violence, without the need for individual reasonable suspicion. The courts have held that such powers, while a significant interference with liberty, can be justified if used proportionately to combat serious crime like gang violence. Moving to arrest powers, PACE Section 24 allows an officer to arrest without warrant for any offense, if certain necessity criteria are met, such as to ascertain name and address, prevent injury or damage, protect a child or vulnerable person, allow prompt investigation, or prevent disappearance.
This replaced the old distinction between arrestable and other offenses.
The person must be informed they are under arrest and the ground for it. Again, the requirement of necessity is crucial as it prevents arrests for minor matters, where other less intrusive means like a summons would suffice.
The courts have emphasized that arrest is a powerful weapon in the police armory that must be used judiciously. There is also a more limited power for ordinary citizens to carry out an any-person arrest for indictable offenses. Turning to powers of entry, search, and seizure, the primary mechanism is a magistrate-issued warrant under PACE Section 8.
The police must show reasonable grounds for believing an indictable offense has been committed, and there is relevant evidence on the premises. Warrants are also available to search for and seize special procedure material like confidential business records. When lawfully on any premises, Section 19 grants a general power of seizure if necessary to prevent evidence being lost or destroyed.
However, the law recognizes that in some exigent situations, the police may need to enter property without a warrant.
Section 17 allows entry to arrest a person, recapture an escapee, or save life and limb. Section 18 permits a search of premises occupied or controlled by an arrested person if there are reasonable grounds for suspecting evidence of the evidence. In exercising any power of entry, the police must first seek consent if practicable, and use no more than reasonable force. The courts retain an important supervisory jurisdiction to review police use of these statutory and common law powers. Judges will assess whether officers complied with the relevant legal criteria and exercised their discretion in a reasonable way, not influenced by improper motives.
This includes considering fundamental rights under the European Convention on Human Rights, like liberty, privacy, and non-discrimination.
However, the courts are also cognizant of the difficulties and dangers of frontline policing. They are wary of second-guessing operational decisions with the benefit of hindsight in the calm of the courtroom.
The concept of reasonableness allows a degree of latitude in dynamic situations where quick judgments are required. The test is not whether police took the optimal course, but whether their actions fell within the range of reasonable responses.
Ultimately, effective policing in a democratic society relies on public support and cooperation.
That's why it's crucial that police powers are not just lawful, but seen as legitimate and fairly exercised.
PACE and its codes try to strike that balance through clear rules and external scrutiny, but as controversial cases continue to arise, it remains a work in progress. The overriding goal is a system of law enforcement that is robust but restrained, promoting both security and liberty as essential public goods. As a final topic, we will be looking at the freedom of assembly and public order. These are important but sometimes competing values in a democratic society, the right to gather and protest, set against the need to maintain the peace and prevent disorder. We'll be looking at how the law seeks to balance these priorities, focusing especially on the common law concept of breach of the peace and key statutory provisions in the Public Order Act, 1986.
Let's begin with breach of the peace, an ancient common law power that remains highly relevant today.
In essence, it allows the police to take preventive action, including arrest, where they reasonably apprehend imminent violence.
The leading case of Howell in 1982 defined a breach of the peace as occurring whenever harm is actually done or threatened to a person or their property in their presence.
Mere criminality is not enough. There must be a risk of violence.
Importantly, the apprehended breach must be imminent, not just remote or hypothetical.
The police must have a genuine and reasonable belief based on objective facts, not just a hunch or a desire to restrict protest.
Retrospective cases have emphasized this requirement of imminence as a vital safeguard against undue interference with individual liberty.
Over time, the courts have clarified that a breach of the peace can occur on private as well as public property.
All that's required is the risk of violence, although in practice, of course, public gatherings are more likely to raise public order concerns.
The power can be exercised without warrant, but any detention must be proportionate. Release must occur as soon as the risk of a breach is past. Turning to the Public Order Act, 1986, this was a key statute passed to consolidate and modernize public order offenses.
Part 1 created a scheme of aggravated offenses, riot, violent disorder, affray, as well as new statutory powers to control public processions and assemblies.
The Part 1 offenses all share some key features. They penalize conduct, causing others to fear for their personal safety.
That fear must be reasonable, though it's judged by a hypothetical bystander test rather than an actual person.
The defendant must intend or be aware that their conduct may be violent or threatening.
The offenses can occur in public or private.
But there are also important differences.
Riot requires 12 or more people using or threatening unlawful violence for a common purpose. Violent disorder needs just 3 or more people using or threatening violence without needing common purpose.
Affray can be committed by a single person using or threatening violence towards another, but a key element is that it must be such as to cause a reasonable bystander to fear for their safety. The Act also created new summary offenses under Sections 4, 4A, and 5, relating to threatening, abusive, or insulting conduct. These are very broad provisions that have at times been controversial for their impact on free speech. Key differences are that Section 4 requires an intent to threaten violence or provoke unlawful violence, Section 4A an intent to cause harassment, alarm, or distress, while Section 5 requires only awareness of that risk. Turning to the statutory scheme for regulating public processions and assemblies in Part 2, the key mechanism is the imposition of conditions by police rather than outright bans.
For processions, advance notice is generally required, and conditions can be imposed on time, place, and manner. For assemblies, conditions are limited to location, duration, and size. The trigger is a reasonable belief that the gathering may cause serious public disorder, disruption, or damage.
Breach of conditions is an offense, but they must be proportionate and can be challenged by judicial review. The courts have tended to respect the operational judgment of police in imposing conditions where supported by clear and cogent evidence. But they have also been vigilant to ensure conditions are not used to stifle the essence of peaceful protest. Notably, the Act gives no general power to ban assemblies. Only trespassory assemblies of over 20 people intimidate or disrupt can be banned in advance. This reflects the especially high constitutional value placed on the right to gather and protest in a democracy. Special restrictions previously applied in a designated area around Parliament Square, but these were repealed in 2011.
Now the area is subject to the usual public order provisions with additional limits on noise and camping. But concerns remain about the adequacy of democratic protest space at the heart of government. Looking ahead, the Police, Crime, Sentencing and Courts Bill currently before Parliament proposes to further extend police condition powers to cover noisy protests and one-person demonstrations.
Critics argue this risks tipping the balance too far against freedom of expression and assembly. But the government contends the measures are necessary to prevent serious disruption.
In conclusion, the legal regulation of freedom of assembly and public order remains a delicate balance.
The Common Law and Public Order Act give the police substantial powers to intervene to keep the peace. But these are balanced by safeguards around necessity, proportionality, and judicial oversight. As ever more novel and disruptive forms of protest emerge in our polarized times, maintaining that balance will be an ongoing constitutional challenge. Despite its idiosyncrasies, the UK Constitution has proven remarkably adaptable and enduring. Its blend of flexibility and stability, its balancing of majority rule with minority rights, and its combination of legal and political accountability mechanisms are in many ways its defining virtues. But it is not without challenges, from tensions between different sources of constitutional authority to the pressures of an unstable union and a rapidly changing world. This brings our podcast to its end. Thank you for listening and see you next time.